Hello, and thank you already for joining us. It's the Employment Law Show. I'm John Scholes. He is Lior Samfiru. Lots coming up on the show today, Lior. And right off the top, the two words that I stumble over every time we do the show. I'm glad we could start this way. Federally regulated employees. I got it that time, what you need to know.
Perfect.
Lior's better with it than I am. So we'll do that here in just a bit. I'll tell you how you reach out anytime to Lior and his crew. By the way, 1-855-821 5900 is the phone number. It is help@employmentlawyer.ca. That's the email address we refer to on the show. You can use that anytime. And we'll also talk about pocketemploymentlawyer.ca. It is like having a lawyer with you at all times on your desktop, your tablet, your phone, your mobile, whatever. It's absolutely free and anonymous. There's a ton of information for you to gather from pocketemploymentlawyer.ca. So we'll get to that and some phone calls from our long-running radio show today as well, Lior. But what do you got going on first, pal?
John, I'm always pulled in 20 or 25 different directions at every given moment because I get a lot of calls. I got a lot of emails, and I respond to everyone and everything because I want to make sure that people have the information that they need, especially these days. Everyone's job, everyone's workplace has been touched somehow by COVID-19. So I think it's more important than ever to know your legal rights, to understand what your rights are. If you've been laid off temporarily, if your job doesn't exist anymore and you lost it, if your job has changed, your hours, your compensation. Maybe it's a situation where the company now is shutting its door and relocating and you want to know what to do then. Maybe you can't work because of COVID-19 or a family member can't work. Well, if any of those things apply to you, you have to get answers because the law provides answers. There are answers. So if we don't cover your specific situation on the show, we only have 30 minutes, not a problem. You can call, you can email, you can get together so that we can explore what your rights are and what you can do about your workplace problem. Please don't ignore your workplace problems. There's no need to. The law is quite good. Someone had emailed me last week saying, well, I have this case involving this major company. I'm not going to mention their name. And they said, well, I know obviously I'm not going to succeed, so is there anything else I could do? And I said, well, that's absolutely ridiculous. It doesn't matter who the company is. It doesn't matter what size the company is. The law is the law. And it's not difficult to resolve these issues. So don't be afraid of the process. If you have a workplace problem, let's connect. But every time we start the show, I like to start off with the week that was, talk about a couple situations that came across my desk very recently, at least one situation. Well, I got a call from someone that worked as a fitness instructor at a gym, and he had been let go. And the interesting thing is he had worked with the same gym for over 12 years, worked there essentially full-time hours, teaching a bunch of classes, involved in even managing a bit of the other fitness instructors. But throughout all this time, he was, quote unquote, an independent contractor. So when he was let go, the gym, he said, well, we're not going to pay you any severance, any compensation because you're an independent contractor. We're going to pat you on the back and wish you all the best. Well, not so fast. And by the way, John, this is actually a very common situation with gyms, with fitness instructors. The law actually would consider them employees, even though they may have worked like this person for 12 years, quote unquote, as an independent contractor. It doesn't ultimately matter because the law decides that. So if you work regular hours and consistent hours and many hours, if the company that you work for tells you what to do and is responsible for getting you work, well, guess what? You are likely an employee. It doesn't matter what you believe you are. It doesn't even matter what you've signed. It doesn't matter what taxes or how you pay your taxes. The law is going to look at the essence of the relationship you have with the company that you work for and determine if you are in fact an employee or a contractor. Many people are misclassified. They're told or they believe that they're independent contractors or they're in fact an employees. Very often happens in gyms, even with real estate agents. So if you have a regular job, chances are you're an employee. And for this person, the fitness instructor, he's owed about a year's severance, 12-month severance, because he's an employee. If he was an independent contractor, he may not have been owed anything. But as an employee, in the eyes of the law, he's owed severance, 12 months. Same with you. If you've been misclassified and you've lost your job, well, you should be getting your severance. In fact, you must get your severance call me. And by the way, pocketemploymentlawyer.ca, we'll talk about that later, but we have a tool there that allows you to find out for yourself if you are really an employee or an independent contractor. So check it out.
Website as well, employmentlawyer.ca, as Lior alluded to at the beginning of the show. That is where you can find our long-running radio shows. Tune in to a station that carries the show for years now. I think we're coming up on almost a decade, 9 years at least. So a lot of information on there, tons of phone calls every week, and we like to play some good ones back and answer them here on this show. So Lior, we'll get to our first phone call for the day right now.
I got a temporary layoff, and within that time, I'm called back to work, and it's 3 days as opposed to 5, which I'm usually used to working. If I give them a written thing that I want it to go back to the regular way it was, then is that sufficient enough, or do I need to send them an email? I've got a letter from them, and it says if I don't come back when I'm recalled within 7 days, I lose my severance, basically.
John, I can't tell you how many times I've seen that. I've seen that pre-COVID, but certainly much more now during COVID. Employee gets called back to work, but company says, well, we're calling you back, but to a different job or different hours or less pay. Well, let's be very clear so that there's no ambiguity. Your employer cannot do this. Now, for this gentleman, his employer is saying that he's going to go from 5 days to 3 days. Simple. There's no nothing to misunderstand here. His employer cannot do that. That is a constructive dismissal, or at least it gives him the right to treat that as a constructive dismissal. So his employer is saying, well, if you don't come back, you lose severance. Nonsense. He can choose to treat that as a termination, again, constructive dismissal, and get his severance. Depending how long he's worked there, depending on a couple of other factors, severance could be as much as 2 years' pay. Now, the only thing I would advise him, if he doesn't want to do that, at least right away, is to tell his employer, I understand you're going through a difficult time, so I'm only going to accept this for the next number of weeks. So I'm going to accept this for a month. And after a month, I expect and I demand to go back to my regular hours. If within a month he's not back, he can still choose to treat that as a constructive dismissal. But the worst thing that he can do is just go back to work, not say anything, and continue working, because then he's considered to have accepted this change. So either put a time limit on it, or you can simply choose to treat that as a constructive dismissal. Same with you at home. If your employer treated or changed terms of employment, hours, compensation, days of work, shifts, what have you, you can choose potentially to treat that as a constructive dismissal before you quit, before you do anything. Let's talk.
You want to reach out as well, here's another place you can do that and ask some questions, terminationquestions.com. Again, you just go there, ask your question, and a member of Lior's team will answer them for sure. We'll get to one now, Lior. This one from Gannon. Gannon writes, I was fired from a senior management position after quarantining due to COVID-19 exposure. When I asked about severance, I was told that because I had only worked there for 2 years, I didn't meet the minimum qualifications for severance. Is that true?
So before we even talk about the ridiculous statement that because he only worked there for 2 years, he doesn't get severance, let's talk about the first part of that he was let go because or after he had to quarantine. Well, depending on the province that Gannon is in, that actually could be illegal. While you're quarantining, in most cases, you have job security. Okay, that's called a protected leave of absence, meaning you cannot be let go. Your job has to still be there for you. So right off the bat, that could be an illegal termination. But there's another issue, which is the fact that even if the termination itself is legal, it's a question of severance. Now, he's been there for 2 years, and there is a misconception, depending on where you're at, that only certain more senior or long service employees get severance. Nonsense, false, myth, ridiculous, whatever word you want to use. Of course you get severance. You could have worked there for 6 months, you still would get severance. So not only does he get severance, he gets substantial amount. Rather than me tell you how much, let's go back to our friend pocketemploymentlawyer.ca and use the severance calculator tool at pocketemploymentlawyer.ca so that you can see and everyone can see how much severance he's owed. So if we take the information and put it in pocketemploymentlawyer.ca, we know he's been there for 2 years, say he's 47 years old, he was offered no severance. As the employer says, oh, you've only worked for 2 years, no severance. Well, you can see the truth, the actual amount at the bottom of your screen there. Not only does he get severance, he gets anywhere from 4 to 6 months pay. 4 to 6 months, even though you only work there for 2 years. Short service employees certainly get severance, even if they've only worked for a short period of time. So that's why it's important to understand your rights. That's why we're here on this TV show. And that's why I created pocketemploymentlawyer.ca. So check it out for yourself.
All right, let's take a short break, Lior. When we come back from the break, federally regulated employees, what you need to know about that. We'll tackle that after break. 1-855-821-5900 is the phone number anytime. And help@employmentlawyer.ca. You can send us an email as well. Come right back, Employment Law Show. People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. And welcome back, Employment Law Show. John Scholes, Lior Samfiru. Let's tackle this. We bring it up every so often on the radio show as well, and that is federally regulated employees. What does that mean? Well, we'll break it down. First, Lior, what's the difference between federally regulated and provincially regulated? Because we hear both those terms with callers as well, right?
Exactly. So the provincial government and the province that you're in has laws that applies to employees that are governed provincially. The federal government over in Ottawa has laws that applies to employees that are governed federally. Now, depending on the job that you're in, either you're federally regulated or provincially regulated. That goes back to our Constitution that outlines the differences between those types of jobs. So there are certain jobs that are federally regulated. For example, telecommunications, TV and radio. So, you know, the people that work for this station, the one you're watching this TV show on, they're federally regulated because, again, it's telecommunications. Or railway, for example, banks. Those are just some example of employees or employers that are regulated federally. Now, the vast majority of employees in Canada are provincially regulated. Most industries are provincially regulated. Some employees, as I've just said, banks, railways, telecommunications, a few others as well, trucking, interprovincial trucking, federally regulated. Now, we're going to talk about the differences here, and the differences are actually not that significant. And we want to talk about that so that you understand that that doesn't mean you have less rights just because you're federally regulated. In fact, in some cases, you may have more rights, but it's those individuals, John, working in those industries that are governed by the laws imposed by the federal government.
Okay, well, outside of the boxes you just checked right there off the top, how does someone know if they're federally regulated or not?
So the easiest thing to do, frankly, is to ask your employer. An employer would know which laws apply, your HR. Usually those employers that are federally regulated, not always, tend to be larger employers. You know, the banks, for example, so they would be able to tell you. You can also go online and the federal government has a list of industries and companies that they regulate. So there's easy ways to find out. You can also call me and I can ask some questions and find out if you're federally or provincially. But again, the main ones, trucking, interprovincial, banking, telecommunications, certain courier companies, those are the main ones that will be governed federally.
Can an employer release or terminate someone who's federally regulated without a reason?
So we know that the general rule is that an employer is allowed to let go of an employee pretty much for any reason, so long as severance is paid. Now, for those employees that are regulated federally, it gets a bit more interesting because for people that are not managers, an employer generally cannot let you go unless they can show legitimately either that you did something awful or that the job doesn't exist. They can't just decide to let you go at random. Even if it's a restructuring, in most cases, they can't let you go unless they can show that the job simply ceased existing. Therefore, that means that for some federally regulated employees, if you lost your job, potentially you can get reinstated if the company did not have a proper reason. That is not something that's available to most employees. Provincially regulated employees can never get reinstated, or almost never. Really, it's just a matter of severance for those employees. But for federally regulated employees, if you want to, you could have that right, the ability to get reinstated. So that's why it's very important for those individuals working at banks, working in other federally regulated companies. If you lost your job, that much more important to get legal advice, because you could have rights that other employees don't have.
Well, for those federally regulated employees beyond the reinstatement, if that doesn't happen, if it comes down to a matter of severance, do they get the same amount? Are they owed the same amount of severance as provincially regulated?
That's a great question. And a lot of people that are federally regulated believe that they get less severance. So if we're talking severance, the full severance, your total entitlements are the same. They're exactly the same, whether you're federally regulated or provincially regulated. Your minimum entitlements may be different, but frankly, it doesn't matter, right? We don't care. What we care about is your full entitlements. So a federally regulated employee with 2 years of service will get the same amount of severance as a provincially regulated employee with 2 years of service, other factors being equal in terms of the job and the age, etc. So you don't get less severance. You can still get as much as 24 months severance. You can still get quite a bit of severance even if you're a short service employee, if you work for a few months. So very important to understand that. Provincially regulated, federally regulated, senior employee, junior employee, long service, short service, you absolutely get severance. And by the way, pocketemploymentlawyer.ca, our severance calculator tool there, works exactly the same for federally regulated and provincially regulated employees. So go there right now, check it out. If you've lost your job, if you're wondering about severance, if you're curious about what you would be owed if the company let you go, pocketemploymentlawyer.ca.
You know, Lior, since the start of the pandemic up until now, I think the topic of temporary layoff has risen to the top of the most popular one when it comes to phone calls and emails. How does a temporary layoff affect federally regulated? Can they be temporarily laid off?
So the same rules apply to federally regulated employees that applies to other employees, meaning if you've been laid off temporarily, you have a choice. The choice is you can accept that layoff and wait at home and go back to work if called back to work. That could last a few months, 6 months, potentially more than that. But that's only if you accept it, if you agree to it. The other option that you have, just like every other employee, is to treat that as a termination of your employment and say, no, I'm not accepting this. I'm not agreeing to be, as you like to say, John, put on ice for a while. I'm going to treat this as a termination and get my full severance. So federally regulated, provincially regulated, it doesn't matter. Your employer does not have an automatic right to lay you off temporarily. If you do, if you are laid off, you can, if you want to, treat that as a termination.
And at what point do one of these employees reach out to an employment lawyer like you?
Well, there's a number of instances. Certainly the easiest one, the basic one, is if you've been let go. Clearly, we need to speak because potentially there's the option of reinstatement. Potentially, certainly, is the issue of severance. If you've been laid off temporarily and you don't want to accept it, you don't want to give the company the right to do it again, then let's talk. Let's talk about getting your severance. If you've been put on a performance improvement plan, you don't think it's fair, you don't think you're being treated properly, if you're bullied or harassed, all those situations, if you're not being paid what you're owed, if the company that you work for change your employment terms, they're paying you less, or they give you different hours, or maybe they demoted you. Just like with any other employee, a federally regulated employee has a right, and in fact, I'm going to say has an obligation to seek legal advice in those situations. So if you're ever in that situation, you know what to do. Let's connect, let's have a chat, and let's decide exactly what the appropriate course of action is for you.
Yeah, you can reach out anytime by phone, 1-855-821-5900. There's also help at employmentlawyer.ca. Employmentlawyer.ca, the website, is where you catch the radio shows. And we'll get to another phone call from our radio program right now, Lior.
My wife, she works for a private electrical company, and she's concerned that they said they're going to be shutting down as of Friday. and there's no work right now because of the COVID-19, if the company shuts down and they say they don't come back at all, like they close the company, could she look at that as being a dismissal, constructive dismissal, and get severance pay?
Well, in that situation, John, if the company shut down, it wouldn't be a constructive dismissal, it would be a regular dismissal, right? Because she'd be out of a job.
Yep.
So it's important to understand that if you lose your job, even if it's the company shutting down, they close down their doors, they're not operating anymore, you are absolutely still owed your severance. The company doesn't get to avoid paying severance by saying we're out of business. No. Now, if the company is bankrupt, we spoke about that on a previous show, bankruptcy is different. If they're in formal bankruptcy proceedings or under bankruptcy protection, then no, severance is not going to be paid, at least not the full amount, and potentially it's going to be deferred for a long while. A company stopping to work, and as a result, you lose your job, absolutely, severance has to be paid. Now, what I wouldn't do in that situation is wait too long. I wouldn't say, well, the company shut down its doors, let's wait a year before we pursue severance. No, you want to deal with it now while the company still has assets, still has accounts receivable coming in, while they still have the ability to meet its legal obligations. So yes, for this person, his wife needs to call me as soon as possible so I can help her get what she's owed. 100% she's owed severance.
Another question we've often had on both this show and the radio show is, if I'm harassed at work, can I still get my severance if it comes down the pike that way? We'll answer that, but first we'll take a short break and get right back to it. 1-855-821-5900, and don't forget pocketemploymentlawyer.ca as well. It's the Employment Law Show, and we're coming right back. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. And back, Employment Law Show. As mentioned, our radio show, you can find that at EmploymentLawyer.ca. And Lior, we'll get to our third phone call from the show to bring it on here right now.
My buddy, he's been working for a company over 14 years. Lately, there's been a problem at work. It's basically a harassment. I told him, basically put everything in writing, give it to him. He wants to know if the outcome says that he's just fed up. How much severance should he collect?
We get that asked often, John, on the show. I certainly get that asked quite a bit. When I speak to individuals, well, I'm being harassed. What do I do if I'm being mistreated or bullied? And what does that mean with respect to my severance? So first of all, obviously, if you've been mistreated, harassed, bullied in the workplace, that's a problem. That's wrong. An employer has an obligation to foster a healthy and supportive work environment, an environment free of harassment. So the first thing you should always do is make sure your employer knows what's happening. Let them know. Tell them about it. Give them the opportunity, if possible, to fix that problem. So file a harassment complaint, speak to HR, speak to the owner, have as many details as possible, and by the way, keep a record of it. Make sure that you have something in writing that you did speak with HR. You don't want the company later to say, you never told us, we didn't know. So in writing, always in writing. Now, if the company doesn't fix the problem, or maybe you can't go to anyone at the company because it's the owner that's harassing you, well, at that point, the law says, wait a second. If despite your efforts, harassment still exists, the company didn't do anything, there's no possibility to fix it, you now can say enough is enough. You now can say, I'm going to walk out of here because of this harassment, but I'm going to make you, employer, pay me my severance, because I'm not walking out of here because I want to. I'm not walking out of here because I feel like it. I'm walking out of here because you've given me no choice. We call that a constructive dismissal, and this person is owed severance. So same thing with the caller that whose question we've played. Let's talk about then how much severance this person after 14 years of service would get if as a result of this situation they walk away from their job. Okay, so let's take that information and let's plug it into pocketemploymentlawyer.ca. You see that on the screen. So we know this person is about 43 years of age, been there for 14 years, a long time. And if they can show that they left their job because of harassment, the severance that it could be owed is as much as 16 months pay, 14 to 16 months pay. You see that at the bottom of your screen. So even though it's the employee choosing to leave, they're leaving not because they feel like quitting. They're leaving because of the harassment. Severance is owed. So pocketemploymentlawyer.ca to see how much you're owed in that situation.
And another website we often talk about and refer to on this show and the radio show as well, for that matter, Lior, is terminationquestions.com. You can go there anytime and ask your questions for Lior and a part of his team. We got time to get Chantel's question here. She says, the owner's, you'll love this one, the owner's asking me to retire after 13 years with the company, I'm 68, so they can reduce staff costs to weather COVID-19. If I don't, they said they may have to fire me with 2 weeks' notice. What are my rights?
Too many illegalities, John. Head exploding. I'm not sure which one to tackle first. Oh my gosh. Oh my gosh. Well, let's start with the retirement angle. And that is the fact that an employer cannot require, threaten, demand that someone leave or resign because of their age. Okay? That's age discrimination. It's as simple as that. Doesn't matter if you're 65, 68, 78, or any other age. An employee now, across Canada, can work till whatever age they deem appropriate. We used to have mandatory retirement, gone. It's been gone for many, many years. So right now, an employer cannot require retirement or resignation by a certain age. So this employer, by demanding and threatening and trying to convince her to retire, that in and of itself would be a human rights violation. And if they then proceed to let her go because she didn't resign, well, then that's also another human rights violation. You let someone go because of their age. It doesn't get more illegal than that. That's discrimination. It's always going to be discrimination. It's illegal. But then that's not illegal enough. Let's make it even worse. They say, we're going to only pay you 2 weeks. Well, this person said they've been there for 13 years. They're going to be owed probably 15, 16, even 18 months severance, months, not weeks. So we have a wrongful dismissal. We have several human rights violations. Illegal, wrong. I really hope that this employer wisens up and doesn't do that. And for this person, yeah, you really got to connect with me because it's illegal in a number of respects.
And you mentioned retiring, and you can't be told to retire or told to resign. It's got to be unilateral and on your own volition, right?
Exactly. By definition, regardless of age, a resignation is something that you do voluntarily and unilaterally. So your employer is saying, I expect your resignation in the morning. That's nonsense. There's no such thing. If your employer wants to let you go, fine, they can. They have to pay you severance. Why would you resign? The only time you should resign is if you've decided, I don't want to work here anymore. I'm going to find another job, or I have another job. I'm going back to school. I'm retiring. That's something that you do voluntarily and unilaterally. That's absolutely fine. A forced resignation is actually illegal. A forced resignation is a termination. So number one, don't do it. But if you felt like you had to because the proverbial gun was put to your head, call me. Call me right away. You're still going to be owed compensation.
We got to go in a minute here, Lior, but quickly I'll ask you, as far as the age is concerned, being 68 years old, those human rights violations, will that enhance the amount of severance as well?
Well, one of the factors that goes into deciding how much severance is your age. So a 68-year-old individual will get more severance than a 38-year-old individual. Sure. So right there, the severance is going to be enhanced. But what they're also going to be owed, a person in that situation, are human rights damages. You have a right not to be discriminated against. And if you've been discriminated against based on your age, or maybe it's something else, your disability, your religion, if you've been discriminated against, there's human rights damages. Our laws don't look kindly on that, and there's going to be significant consequences on an employer.
All right, done for another day. You want to reach out, 1-855-821-5900. Emails help@employmentlawyer.ca, and the website, employmentlawyer.ca, to find our radio show as well. We'll catch you next time, the Employment Law Show.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.